You've probably pictured ancient justice as brutal by default. Eye for an eye, hands cut off, medieval style punishment for anything. Picture a courtroom instead of a torture chamber, a silver fine instead of a severed hand, and you're already closer to how a surprising number of ancient legal systems actually worked. The real record tells a messier story. The oldest known law code in human history didn't rely on maiming or execution for most crimes at all. It relied on fines. And one of the harshest criminal justice systems in recorded history didn't come from some ancient tyrant. It came from Georgian England, less than 250 years ago. Start around 2100 BC in the Sumerian city of Ur, with a document now called the Code of Ur-Nammu, the oldest surviving law code on Earth, predating the more famous Code of Hammurabi by roughly 300 years. Its structure was simple. If a crime happened, then a specific punishment followed. But look closely at what those punishments actually were, and something surprising shows up. If a man knocked out another man's eye, he paid a fine in silver. If he broke someone's bone in a fight, another fine. Most bodily injuries in the Code of Ur-Nammu were settled with monetary compensation to the victim, not violence against the offender. The code covered dozens of everyday disputes this way. A man who bit off someone's nose paid a set fine. A slanderous accusation that couldn't be proven carried its own separate penalty. Even property disputes and marriage-related conflicts had clear, predictable fines attached, spelled out so that both victim and offender knew exactly what to expect rather than being left to the whims of whoever happened to be in charge that day. Only a small handful of crimes, murder, robbery, rape, carried the death penalty. This wasn't chaos. It was one of the earliest known systems of restorative justice, focused on making the victim whole rather than simply inflicting matching pain. This kind of restitution-based justice wasn't unique to Sumer either. Centuries later, early Germanic and Anglo-Saxon law relied on a system called Wehrgild, literally man price, where even a killing could be resolved by the perpetrator's family paying a fixed sum to the victim's family, calibrated by the victim's social status. It sounds transactional by modern standards, but it served the same basic purpose: replacing endless, escalating revenge with a fixed, predictable outcome everyone could actually live with. 3 centuries after Ur-Nammu, Hammurabi's more famous code took a harder line. This is where an eye for an eye, a tooth for a tooth actually comes from. It sounds savage by modern standards, but many historians read it differently, as a limiting principle, not a green light for cruelty. Before written law like this existed, an injury could spiral into an unlimited blood feud, one family's revenge triggering another's, sometimes for generations. Lex talionis capped the punishment at exactly matching the crime, no more. Hammurabi's code applied this literally. If a builder constructed a house that collapsed and killed the homeowner's son, the builder's own son could be put to death in return. Grim by any measure, but notice the constraint built into it. The punishment was never allowed to exceed the original harm, only to match it. Other ancient legal systems built their own safeguards. Egyptian courts collected witness testimony and physical evidence before ruling. Egyptian court records even preserve the names of specific judges and the reasoning behind individual verdicts, a level of documented accountability you might not expect from a civilization more commonly associated with pharaohs and pyramids than paperwork. In Athens, serious criminal trials were decided not by a single judge, but by citizen juries that could number in the hundreds, sometimes over 500 jurors for a single case. Large juries like this weren't just about fairness in the abstract. They made it far harder to bribe or intimidate your way to a verdict, since swaying 500 separate people was a fundamentally different problem than swaying one. Medieval Europe's trial by ordeal gets remembered as pure superstition, forcing a suspect to grab a red-hot iron or plunge an arm into boiling water and judging guilt by how the wound healed. But some historians argue it functioned as more than blind faith. Clergy administering the ordeal had every incentive to manage the outcome, and their ritual's sheer terror likely pushed the guilty toward confession long before the ordeal itself even began. Whether by design or accident, acquittal rates in surviving records were often surprisingly high, suggesting the system worked less like arbitrary torture and more like an elaborate high stakes lie detector. So, if you assumed criminal justice got steadily fairer and gentler as history moved forward, here's the part that breaks that assumption completely. Fast forward to Georgian England in the 18th century, an era of powdered wigs, philosophy, and self congratulatory talk about civilization. By the 1750s, English law recognized more than 200 separate crimes punishable by death. Not just murder, stealing a rabbit from a warren, cutting down a young tree, damaging a fish pond, pickpocketing goods worth more than a shilling, concealing a stillborn child. Children as young as 7 could legally be executed under this system, which came to be known accurately as the Bloody Code. The reasoning behind it wasn't cruelty for its own sake. Lawmakers believed the sheer terror of the gallows would deter crime more effectively than any lesser punishment, especially as rapid industrialization pushed more desperate, displaced people into cities. In practice, it often backfired. Juries grew so reluctant to send someone to the gallows over a stolen handkerchief that they'd deliberately undervalue stolen goods on the record just to keep the sentence below the execution threshold, quietly sabotaging the very law they were sworn to uphold. Put that next to the Code of Ur-Nammu, written over 3,000 years earlier. A system that settled a knocked out eye with a silver fine now sits beside a system that could hang a child for stealing a loaf of bread. History did not move in a straight line from savage to civilized. It zigzagged, sometimes getting more proportionate, sometimes getting far more punitive, often for reasons that had less to do with morality than with which crimes those in power were most afraid of. It's tempting to imagine moral progress as a straight, upward line, with each century a little kinder than the one before. The actual record loops back on itself constantly, deeply humane instincts appearing thousands of years before shockingly cruel ones, sometimes in the very same regions. Just like ancient partying, ancient bathing, and ancient labor all turned out to be more organized and more sophisticated than the popular imagination gives them credit for, ancient justice follows the same pattern, full of genuine restraint and structure, right alongside real brutality, in a mix that never lines up neatly with how old or new the society happens to be. The instinct to assume ancient automatically means harsher says more about how we like to picture the past than about the actual historical record. Some of the oldest legal minds on record were already asking how to make a victim whole without escalating violence. It took supposedly more advanced societies, centuries later, to decide a 7-year-old could hang for a loaf of bread. If a story like this is exactly the kind of thing you want more of, hit subscribe. This has been Unbound Frontier.